Hello everyone, I'm Jason Montgomery, a partner in Husch Blackwell's Higher Education Group. Thank you for joining the program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it may be answered later via email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. To report your hours on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. But only share it if we're really good. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Presenting with me today is Taronda Randall. Taronda provides college and university clients with a comprehensive understanding of the challenges associated with collegiate athletics. She brings invaluable experience to her private practice, having served in athletic departments of major public universities and as a postgraduate intern at the National Collegiate Athletic Association NCAA National Office. She's also a good foil for me and keeps me grounded when I really want to make outlandish arguments. That is all of the housekeeping items. Let's get started with the program. Taronda, take us away.
Thank you, Jason. So let's kick it off with a couple of hot button topics, kind of some quick hitters. With conference realignment, I feel like there are a lot of things happening. At times, I feel like I don't even recognize conferences that are in place now. I'm like, who is in what conference? So we know that Oklahoma and Texas, they both left the Big 12 to join the SEC start next year. Then we had a lot of movement related to the Pac-12. So the USC and UCLA left for Big 10. Oregon and Washington also announced that they'd be leaving the Pac-12 for the Big 10. Colorado, it seemed like, returned home. They used to be a member of the Big 12. They're actually one of the founding members, or the original members, back in 1996. So they went back to the Big 12. And then we have Arizona, Arizona State, and Utah that announced that they'd be joining the Big 12. And let's not forget that Cincinnati, Houston, and UCF left American, and they're joining the Big 12. I feel like a lot of the schools that were in Conference USA went to American, and now some of them are leaving. So it'll be interesting to see where conferences pull from as people move up.
Yeah, and I think the most important takeaway from this is that we're continuing to be an evolving environment, and that's going to have effects, downstream effects on other Division I institutions and perhaps smaller institutions that are part of the NCAA. I think as we see this unfold, one possibility is that governance and other activities could be consolidated within a conference or multiple conference alignment. We're yet to see whether that's going to happen, but like institutions are going to want to be regulated the same as other like institutions. I think what is going to be interesting in the next several years is what response, and we'll talk about this a little later, the NCAA and or the federal government, highly unlikely but possible, has to name, image, and likeness in the variety of state laws that are out there. If there isn't a sufficient solution that's provided either by the NCAA or by the federal government, I do think it is a possibility that these conferences, especially those at the highest level now, there used to be 5, now there's 4, perhaps there'll be less, ultimately at least make their own rules or set standards related to NIL, but we shall see.
So another topic that's in the news is transgender student-athlete participation. So Title IX, the new regs are expected in October of this year. I think people were holding their breath in May, thinking they may come out right before Memorial Day weekend. But the proposed Title IX regulation prohibits categorical bans on team selection based on gender identity. Of course, there's some exceptions that can be made on sport-by-sport spaces, and that's based on legitimate interests such as fairness in competition and preventing sports-related injury. Now, the NCAA has a policy on transgender student-athlete participation that defers to the national governing bodies of the respective sport in terms of protocol and a process that a student must follow in order to compete. But nonetheless, it'll be interesting to see what happens. And I know a lot of states have a state law. So Jason, if you could kind of talk a little bit about the potential impact of state laws and the religious exemption to Title IX, considering the Title IX regs that are coming down the pipe.
Yeah, so this is maybe a little more than a quick hitter, but we do have a published legal alert related to this that came out in April, if you all are interested, with a little bit more of a deep dive. I mean, big picture here, once this regulation we think is going to be implemented in October, it expands Title IX beyond biological sex to gender identity. So that would be a first. That's then going to be challenged, we think, in the courts. And if it's ultimately upheld, then this will preempt any state laws related to transgender participation. You've seen several state laws, including in Missouri, where we're located. Another important point is that religious schools still may exempt themselves through, their religious exemption that is individually provided, for them if they are sponsored by a religious institution or maintain that affiliation. Last piece is that regardless of the NCAA policy or NAIA policy or NJCAA policy, or are there other associations? What am I missing?
I'm sure there are, but regardless of the athletic association's policy, it'd be a safe bet.
Correct. Regardless of their policy, the institutions are going to be individually accountable like they would in any other situation for the application of Title IX on their campus. So in the end, you're going to be left with local responses to, probably relatively rare incidents involving collegiate athletes. Obviously, there was a significant one last year involving Leah Thompson, who was a swimmer at the University of Pennsylvania. And we saw that play out in the media. And in fact, some of the legislation that came out was in response to that. But I do believe that as we move forward, we are going to receive some more clarity in October, and that will dictate how institutions should think about this issue and have their policies in place.
So sports wagering has been another topic that's been in the news. There have been some pretty notable cases or incidents that have been in the media. There was the Alabama baseball coach who was suspected of engaging in sports wagering activities, and also have Iowa and Iowa State that have student athletes that are suspected to have engaged in sports wagering activities. And the NCAA president, Charlie Baker, there's a letter that's been circulating in the media that he sent to a politician that confirmed that they have about 175 sports betting violations that have occurred since 2018 and about 17 active investigations. In response to this, in an attempt to address sports wagering, the NCAA has modified the guidelines for student-athlete reinstatement when individuals are suspected of engaging or have been found to engage in sports wagering activities.
Couple of quick points just generally on sports wagering while we're on that topic. I mean, it really comes down to, and Toronto will go over these points, but the concern over the integrity of contests. So rightfully so, I think the NCAA recognized that there's different levels of penalties that should be associated with sports wagering depending on how that affects the underlying contest. Again, the NCAA rules related to sports wagering not only apply to college athletes, but also apply to institutional staff members, related to gambling. So coaches, athletics department staff members and others that may be involved are prohibited from engaging in any sports wagering activities. Perhaps that might be the next shoe to drop, is an athletic trainer has wagered on a game with inside information and how that might be treated. I will say that it is clear that the NCAA is going to take action. I mean, the number of cases, there's a variety of levels of those type of cases. I think there'll be some direction as to how significant these cases will be for institutions in the next, probably 3 to 6 months when we see the outcome of some of the larger cases that occurred this past spring. I will I mean, just as a preview, having spoken recently with with the NCAA about wagering issue, I do think number one, they're treating all wagering issues, whether it's a coach or an athlete or a staff member, seriously. This is a high priority from the president. So if the president of the NCAA says this is a high priority to the enforcement staff, I think you're going to see more cases in this space, or at least movement on investigations related to this. I don't know. I was thinking about this. When I was at the NCAA, there was a department that was solely devoted to gambling, and it's interesting that that department no longer exists or doesn't exist in the same form, even though the rules have opened up and state laws have permitted wagering more dramatically around the country. So it was an interesting shift, and I think there's now a shift back to a focus on this, which I think is important. The real question, I was looking at cases before we came on here, and it reminded me of a case 20 years ago involving a head coach, Rick Neueisel, who's now a commentator. He actually lost his job in 2003 for betting on tournament brackets. He didn't have any inside information. He was at the University of Washington at the time, and I'm not even sure Washington was in the tournament. But there was an example that was made of him, and I think the amount of money he won was $12,000 or plus dollars. I'm sure there's more money being gambled nowadays. But I guess I bring that up to say is that there's a possibility that there's going to be some situations where the NCAA takes a strict approach, whether it's a coach or athlete or whomever, especially when it involves collegiate athletics.
So when it comes to student athletes, if they have been found to have engaged in sports wagering, they have to go through the student athlete reinstatement process. Some new guidelines are in effect for violations that reported on or after May 2nd of this year. So student athletes who engage in activities to influence the outcome of their own game, so that's that point shaving, or they provide information, insider information to third parties involved in sports betting, or they knowingly participate in sports wagering activities involving their own institution, they're looking at the potential of permanent loss of eligibility. If a student athlete wagers on their own sport at another school, they're going to be imposed with a 50% withholding as well as education. And for other sports wagering violations, the dollar amount will be considered. So we have the thresholds listed on the slide. So 200 or less, sports wagering rules and prevention education, 201 to 500, 10% withholding plus education, $501 to $800, loss of 20% of a season plus education, and for violations involving amounts greater than $800, you're looking at a loss of 30% of a season of eligibility plus education. And one thing that I want to note, that if the violation involves an amount that greatly exceeds $800, then the staff has been directed to consider whether additional withholding, including permanent eligibility, would be appropriate.
So can I bet on horses still, though? That's the real question.
So I'm going to ask you a question. Does the NCAA sponsor a championship in
They sponsor
horse
equestrian.
racing? They do, but is it the same?
No.
Okay.
So the threshold is, does the NCAA sponsor a sport? So NFL, MLS, all those professional leagues are, the equivalent. There's a sponsorship in that sport at the NCAA, so it's also impermissible to bet on those professional sports. But good news for you gamblers out there, boxing, MMA, horse racing, you can still wager on all of those events.
And another thing that the rules kind of provide an exception to, the old-time rivalries that, a tangible item may be up, just bragging effects, or maybe like a trophy of sorts, people can wager on that.
What's the most unique one of those that you're aware of?
And when I say wager, I mean that the wager is the trophy, not additional. Yeah. So make sure I clarified that. I don't want people betting on that thinking that it's permissible.
It was good we needed to build that into the rule, that they could still have the boot or whatever.
Yeah, they still can bet the boot or the trophy of bones. I can't remember all the names of them.
Is there a trophy for the Iron Bowl?
There is, but more than anything, pride matters.
Taronda went to Alabama for law school. She's from Alabama.
I don't say Roll Tide too often, but you set me up for that one. So with the state of NIL, so 32 states have NIL legislation. And so we wonder if you know your state law. We don't know all of them right off the top of our heads, but Jason, I'm wondering if you could speak to some of the unique provisions that different state laws have that you've seen.
Yeah, well, that's kind of a pun, the state of NIL. I like that. Did you come up with that intentionally?
I did. I'm creative from time to time.
So the most recent trend are states revising their state law, amending their state law to include additional opportunities for involvement or engagement between booster groups, oftentimes known as collectives, and individual student athletes, and also allowing for institutions to directly engage in activities with enrolled student athletes related to NIL. In other words, specifically permitting them to arrange for activities. So there's also what I like to call the, everyone hates the NCAA rule, which says, hey, NCAA, we don't care about you, and we're not going to enforce, you can't enforce your rules in our state. Essentially, it's written into the legislation that there won't be penalties associated with permissible NIL under the state law. It's questionable, how that would be viewed. It's a private association. Ultimately, the association could take a stand and see what happens with respect to whether there's any state attorney general or other entity that's going to push back on that. What I think the other piece of this is in Missouri, for example, they permit prospects who are from the state of Missouri to receive NIL if they sign with an in-state school. So this is the Missouri needs better athletes rule, I think I like to call it. Basically, gaming the system for your home school, and that's what's occurring with a lot of these situations. So that then has, again, amplified the need for standards throughout the country, and this push for federal legislation and some other issues that we're going to talk about here.
So some recent guidance from the NCAA was released in June of 2023. And speaking of state laws, I think one piece that I thought was interesting was just the emphasis on the need to actually comply with NCAA rules. So as members of a voluntary association, institutions are still expected to comply with NCAA rules, regardless of whether their state law may allow that type of NIL activity. Institutions are being held accountable for NIL entities, even if they are formed as a separate 501c3, since they meet that definition of a booster or a representative of the athletics interest. Speaking of 501c3, the IRS came out and shared some information regarding collectives. And Jason, maybe you can provide a little bit of context surrounding that information.
Well, they basically confirmed what I think a lot of individuals in this space and tax attorneys had said, that if the entity is designed to provide money to student athletes for their likeness, even if that money is in conjunction with engaging in a charitable activity, that in of itself doesn't qualify the entity for 501c3 status. So I think it'll be interesting to see if there's any actions taken following that advisory memo, which I believe is relatively rare for the IRS, and how that affects the formation of different institutions. I will say one, really public major institution has indicated that they are not no longer going to affiliate with this, the collective as a nonprofit entity. There are probably creative ways for there to be 501c3 status provided to NIL entities, but only perhaps through the involvement directly of institutions, which implicates a lot of other factors, including Title IX and employment issues involving student athletes. So, we're 2 years in, and a lot of this is still evolving in both in real time and how agencies are responding to these issues.
So speaking of real time, we received a comment that the slides are not aligned with the presentation. I will say that we experienced a little bit of technical difficulty prior to starting the presentation, but we were hopeful that we could get it off without too much interruption. So I apologize if the slides are not aligned with the presentation. It might be a little bit of a delay. We might start talking about it and then you'll see it. With that recent guidance, there was also an emphasis on recruiting inducements being prohibited, so boosters are not permitted to have contact with prospects and discuss potential NIL opportunities should the individual decide to come to that institution. NIL compensation cannot be contingent upon enrollment at a particular school or residency in a certain location. That was a unique way that I think some people are trying to circumvent that rule. Event operators or sponsors or even opponents may not pay an entity for competition in which student athletes participate, so that good old no pay for play. And institutions are not allowed to provide assets to a donor as an incentive for providing funds to an NIL entity, so no provision of suites, tickets, and things of that nature.
Toronto, that was a mouthful related to a bunch of like NCAA speak, but let's just break this down. So originally the NCAA said, hey, follow your state law, and if you don't have a state law, and regardless of whether you do or don't have a state law, you can't induce athletes to attend your institution, and it can't be pay for play. And there has to be a quid pro quo arrangement between the athlete and the entity, and all of those rules still exist. What has happened, and I think is what is irresistible in these situations, is that we've put a lot of other guidelines around those rules, but with those rules that are still in effect. So we're in the second year of an interim policy. I mean, it's a long time for an interim policy. While this, I think, some of these things logically make sense, I'm not sure they fit into the larger framework of an interim policy that has a basic component of no inducements, no pay for play, and follow your state law. So that really needs as we're going through this process, there needs to be clarity around what is and is not a violation of NCAA rules. Currently, the NCAA is taking the position that you can violate NCAA rules in the course of an NIL activity. For example, you can induce someone or you can be involved in an arrangement potentially where you're actually involved in directly connecting an athlete to a third-party entity. However, there's also language out there that says, well, you can, connect people, just don't connect them. Don't give them a contract. So I say all this because currently this is all playing out, and we're going to talk about enforcement and current actions. But while there's a lot of language used, there really is little clarity. I think what we can anticipate is the NCAA taking an aggressive approach as to the application of their current rules related to NIL. So if they believe that there was an over-involvement by an institution, they may indicate that whoever the individual was serving as an agent for the athlete in those particular situations. Or they may say this is a bylaw 16 violation because you're being provided a benefit that wasn't otherwise available to other students because they're being connected. All of those are problematic and do need to be sorted out on a case-by-case basis based upon the facts. But again, I'm saying all this to say is, while we have all of this quote-unquote guidance, we have very little clarity as to what it actually means.
There's a jaded Jason that some people who attended our previous presentations have come to love.
I don't know if they love.
So what's next from the NCAA? So the NCAA Board of Directors directed the D1 Council to develop some plans for NIL protections. And those plans really come in the interest of transparency and consistency. So they want them to develop a registration process for NIL service providers and NIL entities or collectives, create a standardized contract or contract terms that will require certain information, and establish disclosure requirements for student athletes and collectives.
Just, because I like to comment on all these slides, Rhonda. It is interesting that we are now having another kind of working group or suggestions. they should look into the trash can and say, hey, what about all those rules that we had for a working group in 2019? Maybe let's dust those off and save some time and see if we can implement any of those. I mean, I'm no rocket scientist, but that would seem easier. But the reality is there's a new president, new directives, and some of these are things that the NCAA feels they can reasonably accomplish potentially without there being federal intervention, which they are still pushing for.
So NIL and Title IX, so the Drake Group has been sending some correspondence to the U.S. Department of Ed, making some requests. And this one in particular that came out in August was to address sex discrimination. There's been some increased contact between institutions and NIL collectives. I think we all can agree that a lot of times they're heavily integrated into the institution and advancing the institution's interests. And sometimes things are being used to provide benefits that are typically covered by Title IX, such as publicity, recruiting, things of those nature. And so with that significant institutional support, there's been a request for guidance, just some clarity in the land of NIL and what it means for Title IX and gender equity.
Yeah, I guess my comment on this is if it's a third-party entity, I think it's still pretty difficult to tie that to the institution. I think you've seen some institutions initially try to be more integrated with this quote-unquote NIL collective or NIL entity and have abandoned those pursuits. I think the most likely scenario is that for those situations involving Title IX, it would be related to the promotion of women's sports versus men's sports. So it would be a treatment area under which Title IX compliance in this context related to gender equity would be evaluated. We still are, silent. There hasn't been any guidance provided related to this. I think it's unlikely that we will get any guidance, but there could be the potential for lawsuits related to this. I think that is a possibility that an entity or a group is being treated so differently by their respective collective that someone tries to tie that into institutional involvement. And the greater involvement the institution has, the more risk there is in this area for an institution, and that's the reality. Although I think there still is a pretty strong argument when that entity clearly is operating as a separate third party from the institution.
And Jason, I know you talked a little bit about some of the enforcement actions in the space and some of the trends, but one of the infractions cases that was believed to be related to NIL was University of Miami. So earlier this year, the negotiated resolution agreement was published, and the case ended up being level 2 mitigated for the university as well as for the head women's basketball coach. And the violation centered on impermissible contact between a booster and 2 prospects that are pretty well known on social media and their parents. Impermissible publicity, just a coach kind of publicizing the recruitment of the student athletes to a particular booster. And ultimately, the head coach was found responsible for her involvement in the violations. Now, this case was processed prior to the effective date of the new presumption in NIL cases, bylaw 1973, which basically says that a violation occurred if circumstantial information suggests that it occurred and the individuals cannot prove that everything they did was in line with NCAA rules. So the COI, there's some interesting language at the top of the case. They warned that it would strongly consider disassociation penalties in future cases involving NIL adjacent conduct.
Okay. So there's a guilty until proven innocent rule. Is that what's going on now?
You could say that.
No, I'd like to say that. So with respect to that presumption, number one, it's a rebuttable presumption, just so you all are aware, and this is only in Division I, I believe, doesn't apply to Division II or Division III schools. But that rebuttable presumption is not unlike what some other rules were in the legislation that, for example, in the past, now there's strict liability for head coaches, but prior to that, there was a rebuttable presumption that a coach was responsible for violations that occurred in his program. So a presumption in these contexts is not unusual from the NCAA. But it is, it can create difficult situations for institutions having to address, media reports and so forth. I will say, though, that what I've seen practically practicing this area is that the focus currently certainly relates to transfer student athletes and tampering and the involvement of NIL in those particular instances. That has been a focus from the enforcement staff. I think we'll continue to see that as a focus. The problem is that if there, really is a legitimate quid pro quo arrangement, even if the amount of money involved seems to not reflect the type of work that's being done, the NCAA is not going to make any judgment on the fair market value of the contract itself, or at least has not been inclined to. And instead, they're really judging as to whether the institution or entity was involved with the athlete prior to them enrolling at the new institution. So if a transfer student, if there's evidence that they were involved with a institution during this period of time before they committed and enrolled at the new institution, that's where I think we could see some potential cases come out. But again, until we see actual activity related to something that was publicized, I think we're going to continue to see I guess I'm going to call it a de-evolution of, as we're going to devolve further into the abyss of NIL, and until there is some really, ground, rock bottom that we'll all hit as people in college athletics.
So it really comes down to the timeline. And one thing that they say, and I don't know if we've talked about this just yet, just a new standard with the credible and sufficient information. So that is a standard that is being expected, that individuals can demonstrate with credible and sufficient information that all communication and conduct complied with NCAA rules. Federal bills related to NIL. We won't cover all of them. We'll just cover a few that are circulating. Jason believes that none of them will be adopted. So we'll talk about that a little bit later. But from a big picture perspective, the NCAA has a couple lobbying goals. And Jason, maybe you can kind of give some context surrounding their goals and intent that the NCAA has in this space.
All right, I'm going to, again, try not to be too jaded here, but the NCAA could just adopt standards tomorrow related to NIL if they chose to. And then institutions would have to react related to their state laws and make a determination as to how they're going to proceed, whether they're going to be involved in the association. So I'm going to put that aside, and there's reasons that they might not do that because of antitrust concerns or Kavanaugh's language in the NCAA versus Alston case. But nevertheless, the NCAA could do that tomorrow. They're not doing it. I think it's a very bad idea for the to involve the federal government in your private enterprise in any context. So we're going to talk about these bills. So now we're getting politicians involved in crafting bills that are going to apply to individual colleges around the country in different areas and in a very complex, integrated way for their sports programs. Terrible idea, and hope it doesn't come to fruition. That's my take on this. The NCAA should independently act, and absent the NCAA independently acting, then the conferences should create general standards for NIL.
Are you going to talk about any of the other goals regarding making sure that student athletes are not deemed employees, or do you want to just wait until later? We'll delve into that deeper.
Well, I mean, let's just speak frankly.
I like hearing you rant, frankly, so I'm giving you the opportunity.
Well, the cat's out of the bag with that, right? So I think that there's some belief that there's inevitability at the highest levels in football and basketball that someone at some point is going to deem these athletes to be employees. So the question is, at what point does the NCAA attempt to draw a reasonable standard that accepts some of this and then takes into account the actual marketplace that's occurring here? So in a best case scenario, you probably carve out some particular sports related to the status of the athletes. But nevertheless, I think in any of these situations, I do believe, I understand why this is occurring at the highest levels of Division I. Again, I don't think this applies to Division II or Division III. I think it's unrealistic, and it's not consistent with the marketplace that we just saw, which is why you've seen commentary related to hypocrisy in the athletics world.
So one of the bills is the College Athlete Economic Freedom Act.
Which, by the way, I love that title. It's like we're trying to help college athletes by giving more rules associated with them. So funny.
Well, in fairness, it's going to allow international student athletes to participate in NIL without violating that F1 student visa status. There's the revenue sharing. And Jason, maybe you can provide some context regarding what California kind of has on the books.
Again, another wacky scenario that where I don't think it actually is going to be passed, but essentially California has put forth a revenue sharing model that would require its institutions, and again, institutions that are involved in the highest level of college athletics, to share in the revenues generated from college athletics with their athletes. They don't single out specific sports, but rather it's based upon the total revenue provided to the institution. It then creates a commission and all sorts of things. But bottom line, it's the result of inaction by the highest levels of Division I to manage themselves and come up with reasonable solutions to this. So I'm more hopeful that there are going to be some solutions that are provided before any sort of California bill becomes law. I do think it's still a long shot. I think it was referred back to committee perhaps. But regardless, California was the harbinger of NIL. So some folks have opined that this is the harbinger of a revenue sharing model that then could be adopted by other states. Now, the only problem with that is most of the other state laws are, I guess, kind of friendly agreements between the local institutions and the politicians. I guess, for example, I think Alabama's NIL law at one point was unanimously adopted. So I think I've said this before, it's the last great bipartisan issue. And then it was unanimously repealed. So I don't know if that says something about what these laws are really all about. I think that revenue sharing is significantly different, and California bill goes to a level that other state entities and state institutions would push back against their legislature, and it would significantly likely harm the ability for those institutions to field programs.
Some other elements of the bill: unrestricted right for athletes to market the NIL. Collectives are going to have the requirement to register with the Federal Trade Commission and report NIL deals to ensure there's no discrimination. There's some penalties that could be imposed under this act related to antitrust.
Just real quick on the F1 piece, I think there's some information out there about some abilities for F1 students to receive compensation through NIL. If they're doing that at their institution from a third party, I think that's a significant risk for the individual and for the institution. It is permissible. Those rules related to receipt of income only apply when the athlete is in the United States. There have been some opportunities for athletes when they're traveling abroad or going to an island for a tournament. It has been one option. I think until, again, we see this become an issue that is addressed by the regulatory body, much like we saw the IRS, it's unclear as to how far someone can push the limits of that. One problem I see with this, hey, go ahead and make money in your home country issue, is that it could all be tied back to their notoriety as a college athlete at a particular state school. And then the question becomes, is the notoriety then what has resulted in them being employed, and is that actual employment in the United States subject to tax in the United States? So complicated issues without any clear-cut solutions. The clearest cut solution for F1 student athletes is don't engage in employment activities unless there's a specific provision or certainly as an institution, if they've received independent advice, that advice, if it's wrong, you as an institution who is issuing that F1 visa would still be held accountable for that.
So the next is the College Athletes Protection and Compensation Act of 2023. So they want to create a central oversight entity, the College Athletics Corporation, tasked with creating and enforcing rules and standards to protect.
The CAC? Instead of the NCAA, we're going to have the CACA. CAC.
I was waiting for you to say something about another entity being created to enforce rules. Also, a medical trust would be created to cover out-of-pocket medical expenses related to athletics participation. Luckily, a lot of institutions already cover that, at least in the D1 level. Creation of health and safety standards, and a requirement that schools report certain information related to revenue, expenditures, academic outcomes, and the requirement that athletes participate in education-related financial literacy, which is already happening for the most part.
Rhonda, in what you've seen, have they carved out levels of institutions in any of these bills, or is it just a standard bill and maybe they understand that this only applies to certain institutions?
There have been some that have carved out, and I will be completely honest with you, I don't want to say like this bill only relates to D1 or, institutions at a certain revenue point, but that has been something when one dives deeper in, you'll see.
That's all right. None of them are going to be passed. I'll bet you. Just like, it's not sports wagering.
We can bet on
you.
this.
Yeah.
Okay. This one, since you like acronyms, is PASS, Protecting Athletes, Schools, and Sports Act of 2023. So NIL deals involving certain things like alcohol, drugs, or those in conflict with the school or conference licenses will be prohibited. Agents and collectives will be required to register with the regulating body. Collectives would be required to be affiliated with the university, which I think is already kind of happening for the most part. There's also the standard contract that would be established. There'd be a limitation on transferring without penalty until an athlete has completed the first 3 years of their eligibility, subject to a few exceptions. So I thought that was interesting, especially in today's time where transfers are happening at a high rate. And guaranteed health insurance for sports-related injuries for uninsured athletes for 8 years following graduation.
Was this the Tommy Tuberville bill?
It is.
Yeah, because he would want to get involved in transfers too. Like, why not just, hey, let's just get our hands into everything as the federal government? It makes absolutely no sense whatsoever, but okay.
Student Athlete Level Playing Field Act, some Federal Trade Commission involvement, so deals over 500 would have to be disclosed. Athletes would not be considered employees. They would be required to be enrolled at a school before being able to engage in NIL activities with the booster. State laws related to NIL would all be preempted. And the creation of a group to make recommendations, this good old working group for you, to Congress and establish an independent dispute resolution process for when disputes occur between athletes and an athletic organization or institution.
Well, now you're speaking my language. I like independent dispute resolution process. Didn't work out well the last time the NCAA did something like that, but just FYI.
I probably could write your content for you at this point because I knew that one was coming. So talking about legal matters, we're going to talk about some cases, and Jason, I want you to really opine on the potential impact of some of these decisions, if you will. So from a historical standpoint, O'Bannon 2015, I think that case lasted from like 2009 to 2015. Ultimately, the trial court found that rules violating student-athlete compensation violated antitrust law. So athletes were then able to receive the good old COA, or cost of attendance. Then we had the Austin case last year, well, not last year, time is flying, 2021, from the Supreme Court. And that ensured that restrictions related to non-cash education-related benefits violated antitrust law. So the NCAA could limit cash for academic purposes, but it couldn't be less than what student athletes can receive for athletic performance. So the dollar amount that they can receive for special participation, championship awards is $5,980. So they can receive education-related benefits up to that amount.
I'm just going to pause, and I know we need to be cognizant of time, but this is why you don't let courts decide how you're going to manage your entity or your association. So in the O'Bannon case, it was the same trial court as the Alston case. In the O'Bannon case, the trial court judge, who's now hearing this next antitrust case, said, hey, schools, you should give up to cost of attendance and also a $5,000 stipend associated with their college athletes' attendance at the university makes sense because you're using their likeness to promote all these activities, and they're providing some benefit to the institution. So that piece of the judge's ruling was struck down at the Ninth Circuit. Then it didn't go to the Supreme Court. In Alston, in front of the same judge, and then we figured out a way to get an additional $5,980 to athletes. Again, different logic. Maybe again, I'm being too conspiratorial or jaded in how this came about, but it's not an accident that in the first case in front of the same judge, $5,000 was the additional amount of money, and in the second case before the same judge, now $5,908. There was a rationale for it that was proposed.
And so with the Alston case, Justice Kavanaugh added a concurring opinion that we think kind of highlights the direction that things are headed. So it was said, I add this concurring opinion to underscore that the NCAA's remaining compensation rules also raise serious questions under antitrust laws. So he had three main points. One, the fact that the Supreme Court was not actually addressing the legality of the remaining compensation rules. Two, although they weren't weighing in the ultimate legality of compensation rules, they're establishing how those rules should be analyzed going forward. So after that decision, the thought was that the NCAA's remaining compensation rules should be analyzed under the rule of reason scrutiny for antitrust. And third, there were some serious questions about whether the remaining compensation rules could actually pass the ordinary rule of reason scrutiny. So
just one point on that. In the Alston decision, it's important to note that the concurring opinion by Justice Kavanaugh was not joined by any other justices. So he was a little bit out on the island. The majority said, we don't want to decide whether athletes should be paid. We don't want to wade into the pay-for-play debate. And so, that really cries out for other alternatives from the relevant association, whoever that might be.
So NCAA, the Johnson case, so student athletes sued the NCAA in 25 schools in Division I, alleging that they should be paid under the Fair Labor Standards Act. Arguments were actually heard on this in February of this year, and the plaintiffs' arguments are focusing on the degree of control that the NCAA has over student-athlete time, class, schedules, major selection, etc. And the NCAA is arguing that the amateurism model should continue and that student-athletes compete without an expectation of payment. Scholarship is almost like a form of payment, if you will. And the trial court held that the NCAA's longstanding amateurism tradition did not demonstrate that student athletes are not employees. So we can't say that they aren't employees under the Fair Labor Standards Act.
So just a quick point on that. The court that held that the NCAA's amateurism tradition did not demonstrate, that was the lower court. This is in front of the Third Circuit. The Third Circuit has heard oral arguments and still has not yet issued an opinion on that. The opinion would simply be that the case could move forward for additional fact-finding and trial to determine, in fact, if FLSA applied in these situations. So as a matter of law, can an athlete ever be an employee? That's the student athlete ever be an employee is what is being decided in the Third Circuit. If the Third Circuit makes the decision, there would be a circuit split, and maybe you said that and I didn't hear you, but.
Good context to add.
Thank you.
So House versus NCAA. So plaintiffs allege that the NCAA and named conferences violated antitrust law by prohibiting athletes from earning compensation based on NIL, and that student athletes should have the ability to share in revenue. This one is not set for trial until January of next year.
But mark your calendars. There is a hearing on September 21st regarding class certification. So for those of you that like to watch arguments in front of courts, I don't think it's going to be on court TV. It's not going to make what was the Depp and Amber Heard trial? It's not going to be like that, I don't think.
Do you think there'll be a Netflix special about it?
There could be. But in all seriousness, it's a threshold question as to whether they can certify class in this situation. A real problem for the plaintiffs in this case is the determination of damages. So retrospectively, determining what the value of individual student athletes' NIL would be when it was impermissible for them to receive NIL, until 2 years ago, until July of 2021. So I do think it's an important, very important discussion and point for those institutions that are named in the case or involved in the case.
So we have lots of questions that are coming in. I think that the probably best approach would be for us to kind of reach out separately on a one-on-one basis and kind of provide some additional context. One thing that I know you like to debate or at least think about, someone asked that if the NCAA actually imposes some type of standard NIL restrictions, would they then be violating antitrust law? What are your thoughts on that? And I paraphrased the person's question. They wrote it much more eloquently than I just asked.
Yeah, I mean, that's the concern, and that's what prevented, I think, the initial adoption. I don't think per se they're violating antitrust law if there's a rationale, again, that they would have to meet the standard related to antitrust violations, which is that there's a basis that's reasonable related to the overall employment or the overall activity in the marketplace. So do they need to do that in order to maintain their product, quote unquote, is probably what the determination would be. Certainly the reluctance here is that once they impose any sort of monetary restriction, that's not to say they can't impose other restrictions related to institutional involvement and even theoretically booster involvement that they haven't done. But if they imposed any monetary restrictions or capped athletes' ability to earn compensation, I think that's where the problem would come. I haven't seen any movement to try to cap athletes, what they could receive, although theoretically, by allowing less opportunity because you have some restrictions, then maybe that could be seen as an artificial cap as well.
I know that was a risk that I was taking, considering we have about 6 minutes left and a couple more slides to cover. But I wanted to at least get your 2 cents on that.
Yep.
So with the National Labor Relations Board complaint against USC, Pac-12, and the NCAA, so they filed an unfair labor practice complaint against those entities, requesting that athletes be classified as employees. I think considering the September 2021 memo that came from the General Counsel, people kind of saw this would be the direction that we were headed in. And the hearing in this matter before an administrative law judge is set for November of this year.
I guess my takeaway, and I know we need to speed through these last slides, is that this is going to be a long process. So not tomorrow, there's not going to be a labor strike at your institution related to the football athletes. I mean, November 2023, it's going to be heard, then there's going to be a decision, then there's an appeal opportunity in federal court. I see that the direction here is to potentially, make these athletes, give them the ability to collectively bargain under the NLRA, but this is a long process that's going to play out over time. And again, my overarching hope would be that there would be a solution to address these issues, because really what we're talking about in this complaint is certain athletes. They're not saying that every athlete falls under the act. They're saying certain athletes, and really what they're talking about are football and basketball players.
So I think from a historical standpoint, this is kind of in the backdrop of the unionization efforts by Northwestern athletes about 8 years ago. But this seems to be a much broader issue because theirs was more so geared toward private universities, student athletes at private universities.
Well, I mean, that's a good point. So they try, what they're attempting to do here is to bring in entities with other public members, so the Pac-12 and NCAA. It's unclear whether that will be successful in this context, and we have much better experts that actually have published some legal alerts and documents on this, who are experts in labor relations that opine on that as well.
So some other considerations, especially for this time of year. I know a lot of people on campus are busy with the return of students and just starting the good old fall competitions, but some things to be aware of. So the NCAA policy on campus sexual violence, the attestation is due in November. There are a couple other attestations that are due as well. This is actually an association-wide policy, so it applies to all 3 divisions. And each chancellor or president, the AD, as well as the Title IX coordinator has to attest that the athletics department is informed of the institutional policies and processes regarding sexual violence, that the policies and the name and contact information for the Title IX coordinator are available and provided to student athletes. That education has actually been provided to student athletes, coaches, and student athletes. There's some disclosure requirements for incoming, continuing, and transfer student athletes related to whether they have had any type of finding against them for sexual violence, interpersonal violence, or other acts of violence. And there's a requirement that institutions have taken reasonable steps to confirm whether student athletes have been disciplined through a Title IX proceeding or criminally convicted of sexual, interpersonal, or other acts of violence. Jason, maybe you can talk a little bit about the reasonable steps, because I know sometimes institutions have asked us, like, what would be considered a reasonable step? Just some ideas, if you will.
Yeah, and we need to kind of go through it. So I do think a reasonable step is dependent on the resources that are at your institution. And so a reasonable step for a small Division III institution with 1,000 student athletes are different than a reasonable step for a large public institution that has multiple departments that can assist in helping with this. So the big question that we've heard is, should you ask all high schools where athletes have come from that, whether they have been involved in these activities? What we have generally advised is that with transfer student athletes, it's reasonable that you should independently request information from the previous school where they attended, that's a reasonable step, whether or not they disclose that they were involved in any sort of disciplinary activity, because the genesis of this policy was the result of issues related to transfer student athletes. So we advise that across the board for all institutions. With respect to high schools, different institutions are going to take different approaches. We do not believe that it is necessarily reasonable for you to go to every incoming student athlete high school to request information, although some institutions have gone to that level of detail.
So some other attestation requirements, and these are related to Division I. So we have the annual attestation of compliance that's also due November 3rd. They were nice enough to have the due date consistent so that people could remember it. And that's just basically attesting that you have complied with the NCAA rules, and the president has to sign off on that. So the NCAA Diversity, Equity, and Inclusion Review, so it's required once every 4 years. D1 institutions are expected to complete that initial review by November of this year. D1 conferences have until November of next year. The NCAA actually has a framework that's available for everyone to refer to and use. Some other upcoming attestations, and this is just looking forward, 2024 and beyond. So review of health and safety, support services. I feel like the pendulum swings back and forth, so we're back to requiring a compliance review, and also compliance education. And Jason, if you will, I'm going to kind of run through the remaining slides because we're at our time. So another thing that has been a hot button issue, just coaches' conduct and student athlete well-being, and we believe that that's just kind of showcasing the importance of clear expectations regarding what your coaches are expected to do. Make sure that you're reviewing the team handbook and program just to see what rules are actually out there. Having an anonymous reporting mechanism, I feel like it's kind of a double-edged sword, but you want to know what your student athletes are feeling, because I feel like once we do these reviews, a lot of times we find out that at some point someone had a concern, but maybe they didn't feel like they had a place that they could go. And just making sure that you have policies and procedures in place for handling any type of reports or complaints related to that. Some proposed Division I legislation for consideration at the D1 Council meeting in October. A lot of this is geared toward transfers that I'm going to highlight. So we have football with the elimination of the initial counters and annual signing limit, progress toward the degree requirement to qualify for use of that one-time transfer exception, and also this reduction of the transfer window from 60 days to 30 days, because we think that a lot of the activity happens within that time period.
All right, we're sorry we're just a little bit over, and we apologize again for any technical difficulties you all experience. We want to thank you for joining us today. Thank you, Taronda, for the work. We hope the information was helpful. We'll do our best to respond to the questions that came in. A reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. And be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your needs. This concludes the webinar. Thank you for joining us today.